So let's get back to some of the crazy claims that are made by the Chinese. And in this case, we're going to talk about Taiwan. And we're going to talk about the idea that in order to transfer territory from one state to another state, as what allegedly happened after World War II, when Taiwan was supposedly ceded from Japan to China, it requires a ratified treaty. So let's take a look at what actually happened, and then let's take a look at the international law that is in question. So China claims that the Cairo Declaration and the Potsdam Proclamation transferred sovereignty to China after World War II. Now, as per the Treaty of Shimonoseki in 1895, okay, Taiwan was under Japanese sovereignty, okay, from 1895 through the end of World War II. Okay, so Japan was the sovereign power. Now, this document, the Cairo document and the Potsdam document, were not ratified treaties, which is a stark contrast to the Treaty of Shimonoseki. So let's take a look at what the Treaty of Shimonoseki says. Article 2, Clause B states, the island of Formosa, Taiwan, together with all islands appertaining or belonging to the said island of Formosa. Okay, that is a specific treaty clause that transfers sovereignty over Taiwan, back then known in the West as Formosa, to Japan. Clause C, the Pescadores Group, Honghu, that is to say all the islands lying between the 118th and 120th degrees of longitude east of Greenwich and the 22nd and 24th degrees of north latitude. So those are the clauses in the Treaty of Shimonoseki that explicitly transfer sovereignty over those islands to Japan. Now, Article 11 of that treaty lays out the requirement for ratification, which is extraordinarily important because without the actual ratification of the treaty, which we are going to see in examples that I'm going to go through in a few minutes, that ratification is absolutely necessary in order to effectuate a transfer of sovereignty. So, Article 11 of Shimonoseki says, the present act shall be ratified by their Majesty, the Emperor of Japan, and the Emperor of China. I'll talk about that phrase, Emperor of China, in a minute. And said ratifications shall be exchanged at Chifu on the 8th day of the 5th month of the 28th year of Meiji, corresponding to the 19th day of the 4th month of the 21st year of Guangshu, which happens to be May 8th, 1895. Now, it actually does not say China in either the Chinese or the Japanese texts of the treaty. Yeah, in the Chinese text of the treaty, it says Da Qing Di Guo, which literally means the Great Qing Empire. And in Japanese, it says Daishin Teikoku, which is basically the same thing, the Great Qing Empire. In neither version of the treaty does it actually say China. So when we look at Treaty Shimonoseki, that was ratified. Neither Cairo nor Potsdam, not only were they not ratified treaties, they weren't even signed. They weren't even signed, and that was obviously that was brought up in a previous video that I did regarding the fiction of the idea that Japan was limited to the home islands. So that brings us to the question, which I've already alluded to, but I'm going to explicitly ask it. Is a ratified treaty required to transfer territory from one state to another state? So when we look at the foundation of international law, of course, over the 20th century, a lot of customary international law was codified into conventions. Now, but not all. Right? So how has international law been traditionally formed? It has been formed by repeated state practice with what is called opinio juris, okay, or the intent to create law. So when you have the repeated actions of states combined with the intent of those states to create international law, that is how customary international law was largely created in the pre-World War II context. So it is imperative to examine state practice of the transfer of territory. So let's look at a few examples. Okay, so the United States and Russia, okay, signed a treaty, the Alaska Cession Treaty, in 1867. In Article 1 of that treaty, it states, His Majesty the Emperor of all the Russias agrees to cede to the United States by this convention immediately upon the exchange of the ratifications thereof. It's like even in the first article, it mentions ratifications. All the territories and dominion now possessed by said majesty on the continent of America and in the adjacent islands. Okay, so there's the clause of transfer. Now, there was also a payment of funds in another article. In that same treaty, Article 7, when this convention shall have been duly ratified by the President of the United States by and with the advice and consent of the Senate, on the one part, and on the other by His Majesty the Emperor of all the Russias, the ratification shall be exchanged at Washington within 3 months from the date hereof, or sooner if possible. So we have a treaty in which Alaska was transferred from Russia to Washington, and Washington paid St. Petersburg money in order to effectuate that transfer. Not relevant in this case. Okay? What is relevant is that one, there is a specific clause of transfer, Article 1, and a specific requirement for the ratification of the treaty, Article 7. Let's look at another example. The Treaty of Roskilde, 1658. Articles 3 and 4 explicitly ceded significant Danish territory to Sweden. These territories included Scania, Bornholm, Trondheim, and Halland. Okay? Those are territories that had long been part of Denmark, and this is the period of the Swedish Empire where the Swedish was at the height of its power and forced Denmark to give up significant territory. So if you look at Article 22, now the original text of the treaty was in Latin, which was common back then. Yeah, here is an English translation. This present treaty shall be ratified on both sides by their royal majesties within the space of 10 days or sooner if possible. And the instruments of ratification shall be exchanged here in Roskilde. Okay? So it is clear again from very early on in the Westphalian state era, okay, which this is only 10 years after the Treaty of Westphalia. It is clear from this and from many other examples that territorial transfers must be explicitly laid out in ratified treaties. So now, what's another argument that the Chinese sometimes make? The Chinese sometimes make the argument that though the Qing ceded Taiwan to Japan, that it retains some kind of residual rights and that it must be consulted. Because one of the arguments that is made by the Chinese is that when the Peace Treaty of San Francisco was signed and ratified, China was not a part of it. And so China says, well, we weren't a part of it, so the treaty is not valid. And in fact, this is an argument that some in China make today to claim that, in fact, the San Francisco Peace Treaty is not a valid treaty, despite the fact that it was ratified by 48 allied states. Get into that another day. So they claim that China must be consulted before the island is disposed of. Completely and totally false. So in the 1870s, there was a war called the War of the Pacific in South America between Chile on one side and Peru and Bolivia on the other. And one of the treaties that came as an outcome of that war was the Treaty of Lima in 1929. Article 2 of that treaty states the territory of Tacna and Arica shall be divided into two parts, Tacna for Peru and Arica for Chile. The dividing line shall start from a point on the coast to be named Concordia, 10 kilometers north of the bridge over the Uta River. Okay, so there is a supplementary protocol, okay, which is unusual in treaties, that actually does explicitly grant residual rights to both Peru and Chile. Okay, so that supplementary protocol, Article 1 states the governments of Chile and Peru may not, without previous agreement between them, cede to a third power the whole or any part of the territories which remain under their respective sovereignties. Okay, so here you actually do have explicitly mentioned the retention of residual rights by Peru and Chile to the territories that were agreed to in this particular treaty. And that actually became relevant because Bolivia has been negotiating with Chile because Bolivia lost access to the sea as a consequence of the War of the Pacific. Bolivia has been trying to gain access to the sea, and Chile had actually come to an agreement with Bolivia over some of these territories that had been ceded to Peru, but Peru objected. Yeah, and so it didn't happen. Okay. Now, this is actually explicitly stated. There is no such clause in the Treaty of Shimonoseki that grants the Qing or any of its successor states any residual rights. Article 13 of the Treaty of Lima is the ratification protocol. The present treaty shall be ratified, and its ratification shall be exchanged in Santiago, which is the capital of Chile, as soon as possible. So once again, an example of very clear territorial cession, very clear process of ratification, and in this case, explicitly stated residual rights. Let's look at another example that can also get us to the residual rights aspect. Denmark. Denmark fought a war and lost. Yeah, Denmark was at one time a relatively great power, lost territory to Sweden, as we mentioned earlier. Now it's losing territory to Prussia and Austria. Treaty of Vienna, 1864, Article 3. His Majesty the King of Denmark renounces all his rights to to the duchies of Schleswig, Holstein, and Lauenburg in favor of their Majesties the Emperor of Austria and the King of Prussia, and undertakes to recognize the arrangements which the said Majesties shall make with respect to those duchies. Okay, so basically, Denmark is going to accept whatever Prussia and Austria decide to do to dispose of those particular territories. Article 24. The present treaty shall be ratified, and the ratification shall be exchanged in Vienna within 3 weeks or sooner if possible. So again, very explicit clause for the transfer of territory and a very explicit criterion for ratification. So Austria and Prussia then signed two further treaties. Denmark retained no residual rights here. Okay? There's no process for it in the treaty. And when you look at the next two treaties, Denmark was not involved. So no one gave any notion that Denmark had any residual rights because it simply was not mentioned in the treaty. So in 1865, you had the Gastein Convention, Article 1. Now, this one, is it actually a ratified treaty or not? It actually doesn't matter because this one actually does not um, deal with an actual cession of territory. It's basically an agreement between Prussia and Austria about how to divide those those territories that are mentioned in the Treaty of Vienna. Article 1, the exercise of the rights jointly acquired by the high contracting parties by Article 3 of the Treaty of Vienna on 30 October 1864 shall, without prejudice to the continued existence of those rights of both powers, pass with respect to the Duchy of Schleswig to His Majesty the King of Prussia, and with respect to the Duchy of Holstein to His Majesty the Emperor of Austria. So here Prussia and Austria are basically formalizing the division because at first they were going to rule them as a condominium, where both of them would exercise sovereignty. Didn't work out because there was a growing rivalry between Catholic Austria and Lutheran Protestant Prussia, and so it didn't work out. They signed this agreement. There was a final provision. This one's actually not as clear cut a provision uh, of ratification as in some of the others, but there is ratification, and even so, it's not really necessary because it's actually not a territorial cession. But it says the present convention shall be approved by their Majesties the Emperor of Austria and the King of Prussia by exchanging written declarations at their next meeting. And the historical record states that, in fact, instruments of ratification were exchanged on 19 August 1865. Now, note that this is not strictly territorial cession, but at the same time, Denmark retained no residual rights. The following year, Prussia, and Austria fought a war. Peace of Prague, 1866, Article 5. His Majesty the Emperor of Austria transfers to His Majesty the King of Prussia all the rights which he acquired by the Vienna Treaty of Peace on 30th October 1864 over the duchies of Holstein and Schleswig. Okay. Now, there was actually a provision for the citizens to vote in Northern Schleswig, but that was abrogated. Okay. So they were never actually, at least under this treaty, given an opportunity to decide whether or not to return to Denmark. Regardless, Denmark was not actually involved in this treaty because Denmark had no residual rights, even though the contracting parties did, in fact, note that it had one, previously been part of Denmark, and two, actually did have a substantial Danish population. Regardless, Denmark was not involved in the treaty, and the people never did get the ability to determine whether or not they wanted to join Denmark. Same treaty, Article 14. The ratifications of this present treaty should be exchanged in Prague within a period of 8 days or earlier possible. You notice back then you had kings, and they were able to, of course, ratify treaties of their own accord. Didn't, for example, the United States, the president ratifies the treaty but needs the advice and consent of Congress to do so. So, ratified treaty, Peace of Prague, Denmark not involved. So, that does not end the saga of this territorial tug of war between Denmark and Prussia/Germany. because some of that territory was actually regained by Denmark as a consequence of World War One, even though Denmark was a neutral power. So, in Article 109 of the Treaty of Versailles, it states, quote, "The frontier between Germany and Denmark shall be fixed in conformity with the wishes of the population for this purpose. The population inhabiting the territories of the former German Empire, situated to the north of a line, shall be called upon to pronounce by a vote." So there were actually three regions that were discussed here. And this was consistent with the notion of President Woodrow Wilson and the 14 points and the self-determination of peoples. And in fact, this idea of self-determination of peoples, which is pretty new in the 20th century, is going to be enshrined as international law of the 20th century develops. So, three regions. Northern Schleswig voted to rejoin Denmark. And so at this point, that region was reunited with Denmark. Central Schleswig voted, but voted to remain German. Southern Schleswig, which had an overwhelmingly German population, did not have a vote and was retained by Germany. Now, in the Treaty of Versailles, it also states, quote, "The present treaty, of which the French and English texts are both authentic, shall be ratified. The deposit of ratifications shall be made at Paris as soon as possible." It should be noted that though the United States signed the treaty, it was the Senate never gave its advice and consent, so the President of the United States was unable to ratify the treaty. The United States signed a separate treaty with Germany. Now, one more area I want to look at. Alsace and Lorraine, territory on the border of France and Germany. Treaty of Frankfurt after the Franco-Prussian War in 1871, Article 1. France cedes to His Majesty the German Emperor King of Prussia the territories designated in Articles 1 and the additional articles, okay, consisting of part of the former French provinces of Alsace and Bas-Rhin and Haute-Rhin, except for Belfort and Lorraine, which is most of Moselle, plus parts of Mivit and Bussac. So, very strict, very clear clause of cession. Ratification of the definitive peace treaty was carried out on 16 May 1871. So, specific article of cession, and it was a ratified treaty, but not the end of the story, because after World War One, France was on the winning side, and they really imposed what many regard to be a rather humiliating treaty on the Germans, the Treaty of Versailles. Now, keep in mind, one of the arguments that are made by the Chinese is that because Taiwan was part of the Qing Empire, and in reality, not all of Taiwan actually was, but let's accept the argument that it was. Fine, doesn't matter. That because of that, not you did not need any specific clause in any ratified treaty, because by right, the successor state of the Great Qing Empire, the Republic of China, would regain sovereignty over said island. But that's not actually the case, because the Treaty of Versailles actually must specifically lay out the the terms of the so-called retro-cession, okay, which is what the Chinese claim happened with Taiwan on August 20, sorry, not August, October 25th, 1945. Article 51 of the Treaty of Versailles. The territories which were ceded to Germany in accordance with the preliminaries of peace signed at Versailles on February 26, 1871, and the Treaty of Frankfurt, May 10, 1871, are restored to French sovereignty. And as already noted in the Denmark example, this was a ratified treaty. So it took a ratified treaty with a specific transfer of sovereignty mechanism in the Treaty of Versailles for France to regain the former rights that it had over those territories in Alsace and Lorraine. So, three key takeaways from this that will make the Chinese squirm. One, a ratified treaty is clearly required to transfer territory from one state to another state. The historical record shows this. There's consistent state practice in this regard and consistent opinio juris. Okay? And even after World War II, the United States, UK, France, and others specifically sent aides-memoires to Nanjing when Nanjing unilaterally announced an annexation of Taiwan, stating that there had in fact not yet been a ratified treaty and that Taiwan was still under de jure Japanese sovereignty. We'll get to that in more detail in a future video. The second takeaway. No residual rights are retained by the ceding state unless explicitly provided for in the treaty. So the Treaty of Lima between Peru and Chile did in fact specifically grant residual rights over the territories in question in that treaty. There was no such residual right given in the Treaty of Shimonoseki to the Great Qing Empire or any of its successor states. 3. Another ratified treaty is required to restore sovereignty to a prior sovereign. That shoots down one of the Chinese arguments, stating that the Chinese naturally regained sovereignty over a lost territory. The historical record does not show that to be true. The historical record shows, in fact, that specific, explicit sovereignty clauses must, in fact, be present in a subsequent treaty. So these three main takeaways, and I'm sorry for the length of this video, but a lot of international law does require the citation of examples because state practice is extremely important in the formation of international law, where you don't have it clearly stated out in a treaty. For example, the Vienna Convention on the Law of Treaties, which I'll mention in a future video. But these 3 points, as pertaining to international law, really do show that the Chinese situation, the Chinese stance, doesn't really hold any water at all.